They installed solar panels to power their house. But months later, their neighbor built a tall shed that blocked the sunlight and cut the system's output in half.
Your Honor, I installed solar panels on my roof last year. They worked exactly as expected until my neighbor built a tall shed right along the property line. Once that structure went up, my roof started sitting in shadow for most of the afternoon. My power production dropped by nearly half. These photos show the shadow covering them. The energy reports track the exact drop in output the week that structure went up.
Your Honor, that shed is completely on my land. I followed the property line and the city permit. My neighbor decided to put solar panels on her roof. That was her choice. I believe I shouldn't have to redesign my property because she wants more sunlight.
The court understands property owners have the right to build on their land, but that right has limits. The evidence shows the solar system existed first and functioned normally before the structure was built. The court finds that the structure created a substantial and avoidable obstruction. Property rights do not include the right to deliberately interfere with an existing lawful use next door. The defendant is ordered to modify or reduce the structure so the solar panels receive direct sunlight again. Failure to comply with this order will result in fines and further enforcement by the court.
She abandoned their dying father for 3 years, but when she found out about a $500,000 vintage car hidden in the barn, she showed up with a tow truck to steal it from her brother. Watch the judge put this greedy sister in her place.
I bathed him for 3 years, Your Honor. I changed his diapers while she was vacationing in Aspen. She didn't even show up to the funeral. Dad told me on his deathbed, fix up the Mustang, son. I don't want to fight my sister, but I am honoring his exact wishes.
The will says I get $50,000, Your Honor, but a 1969 Shelby Mustang is a titled vehicle. It is not just personal property attached to the land. It's worth $500,000. I am entitled to half the value of those cars.
The phrase property located on the real estate might be poorly drafted by the lawyer, but under the law, the testator's intent is paramount. He knew exactly who was holding his hand at the end and who was absent. The cars, the land, and the legacy belong to your brother.
The city parked a 10-ton backhoe on this man's driveway just because it was handy. When it cracked the concrete, they told him they were immune to the bill. But they forgot one thing. The Texas Constitution doesn't have a shortcut for thoughtlessness.
We was out at Lake Travis that weekend, had the grandkids up there, so I didn't even see the mess they left till we got back Sunday evening. This is an inverse condemnation issue under the Texas Constitution. They had all the space they needed on the street. Nobody gave them permission to park on my driveway. It was the public main, not the service line to my house. The main is under the road, not my driveway. It was unnecessary for them to be on my driveway.
But this was an emergency repair under the Tort Claims Act. This issue falls under sovereign immunity. Your Honor, they were out there at 3 a.m. on a Saturday. There isn't a waiver here for property damage. Legally, I just don't have a way to settle this.
Yeah. Okay. But they parked it on his driveway. If they're on his property to facilitate a city repair, that is a taking. And the street was wide open. I mean, I don't get the rationale here. Why should Mr. Tullis pay for their mess? That's the part I'm struggling with. If you damage property for public use, you pay for it. The city is liable, I'm finding, for the plaintiff.
The state sent him an $80,000 fine for his pond, based on a guess they made on the roadside. Watch the judge shut down this drive-by shakedown.
DEP is classifying a 2-acre excavated pond on my property as a regulated wetland. This land has been used for upland grazing for 60 years.
Under Chapter 105, a physical entry isn't required for a presumptive violation if the hydrological connection is identifiable from the public right-of-way. Based on remote aerial surveys with the drone, what we can see on recent satellite and roadside visual inspection, we identified hydrophytic vegetation patterns in the drainage swale.
Never requested a site visit. They didn't take any samples. They're classifying a dry logging tract as a waterway because it was the only way they could justify filing this citation from over there on the road.
Did the department perform a formal 3-parameter delineation on this property? Because I'm looking at what you sent in, and it looks like a drone photo and another couple you took from the road.
Well, sir, respectfully, as I stated under Chapter 105, physical entry is not required for a presumptive violation if the connection is identifiable from the public right-of-way.
You're certainly allowed to issue a citation from the road, but you cannot sustain one in this court on a guess. You sent pictures to the court. He sent in a soil test from a certified wetland scientist. The Commonwealth has no evidence to rebut his findings. You failed your burden, and the violation will be vacated.
That
That is not frustration. That is deliberate property damage.
A woman dumped a cup of hot coffee into the interior of a parked Lamborghini after arguing over a parking spot. Seconds later, the sugary liquid seeped into the dashboard electronics. The repair estimate shocked the courtroom, and the judge's reaction stopped everyone cold.
Your Honor, he cut directly into the parking space I had been waiting for and acted like it was nothing. I was frustrated and dumped my coffee into the car without thinking. It was just a cup of coffee, not gasoline or paint.
Your Honor, that Lamborghini Huracan has exposed electronics running through the center console and dashboard. When she threw the coffee inside, it soaked into the control panel and shorted several modules. The repair estimate alone is over $18,000.
You threw hot coffee into the interior of a luxury vehicle because you lost an argument over a parking space. That is not frustration. That is deliberate property damage. This court orders full repair costs and an additional $10,000 in damages.
Now tell us, did the judge make the right decision?
That's today's breakdown. If you're as shocked as we are, hit follow and share this with someone who needs to hear it. More unbelievable cases are coming soon.